Right, I'm going to now have the third of my series of brief talks about current measures in process within the EU, which are going to have potential effects on commercial and maritime enterprises. Now, part three is entitled Human Rights and Business. Ruggie gets mandatory. This is obviously a reference to the Ruggie guiding principles, which, as its name suggests, are simply guiding principles for um, home states and host states and for business enterprises. There's nothing mandatory about it. Well, as far as the EU is concerned, this directive proposes something a bit more than just should. It is going to propose mandatory due diligence obligations on business enterprises within the union, and also business enterprises who are outside the union but are doing business within the union. This has been in the news recently. Back in the winter, a couple of judgments which involve environmental claims against transnational corporations. And in the first one, it's a judgment in ACPAN in the Netherlands, in the Court of Appeal in The Hague. And I've just quoted the headlines from The Guardian of the 29th of January 2021. And that is one of the affected persons in Nigeria, just giving an indication of what the effect is of the leaks which have been coming from Shell pipelines, inland pipelines carrying oil. And a judgment was obtained in The Hague against the subsidiary company operating in Nigeria. The parent company was not held liable, though it was ordered to take various cleanup measures. And that was followed shortly by the Supreme Court in the UK in Parby versus Royal Dutch Shell. It's a similar claim. It's an environmental pollution claim. The allegations in a different part of Nigeria, Ogali and Bile, saying that Shell's operations have caused severe pollution to their drinking water because there are leaks coming from pipelines. The causes of those leaks is somewhat disputed, but what this case says is that there is a prima facie case that the parent company might have a direct duty of care to those affected by the subsidiaries' operations in Nigeria. And because of that, leave can be given to serve out of the jurisdiction on the Nigerian subsidiary as a necessary and proper party under the civil procedure rules. So even if that means that when we get to trial, if the trial judge says actually, although there isn't really a direct duty of care by the parent, so we're not going to hold them liable, you've still got the subsidiary companies before the court, and it may well be that there will be a finding that they are liable. So this is the sort of national context of litigation as regards transnational environmental torts, and it would be a similar set of battlegrounds as regards claims involving human rights violations. Now, this directive was proposed about a month later, 10th of March, and what it does, it lays down the value chain due diligence obligations of undertakings under its scope. And they've got to take proportionate and commensurate measures and make efforts within their means to prevent adverse impacts on human rights, the environment, and good governance from occurring in their value chains. And they've also got to properly address such adverse impacts when they occur. So we're going to get obligations, not just this is what you should be doing. We're going to have due diligence obligations. And as well as owing obligations, the directive aims to ensure accountability in accordance with national law for the adverse impacts on human rights, environment, and good governance which are caused by undertakings, that either that they cause or contribute to in their value chain, and to ensure that victims have access to legal remedies. So this is actually going to be a hard law measure. It's not just enough to put up, voluntarily to establish due diligence procedures within your organization and put nice stuff up on your website. There's going to be hard law applying. So let's have a look further at what is on the menu in this directive. Article 2, the scope. It can apply to large undertakings governed by the law of a member state or established in the territory of a union, and also to all publicly listed small and medium-sized undertakings, as well as high-risk small and medium-sized undertakings. Obviously, we might think that this has got nothing to do with the UK because we are not part of the union. However, if we look at number 3, the directives should also apply to these large undertakings, publicly listed small and medium-sized undertakings, etc., which are governed by the law of a third country, UK perhaps, and are not established in the territory of the Union, when they operate in the internal market, selling goods or providing services. And they have got to fulfill the due diligence requirements established in the directive, which is then going to be transposed into the legislation of the member state in which they operate. So this will have an effect on UK companies which are actually operating in the internal market of the EU, selling goods or providing services. Various definitions, and they're quite wide definitions actually. Article 3, what's a business relationship? Well, it includes subsidiaries and commercial relationships of an undertaking throughout the value chain. So that goes down to suppliers, subcontractors, which are directly linked to the undertaking's business operations, products or services. The way of linking subsidiaries with the parent company through the tort litigation, which we've seen in cases like Parby, where you're trying to find a direct duty of care. This is something which I think will make it easier to impose obligations and potentially civil liability in respect of what your subsidiaries do or do not do in their overseas operations. Suppliers, any undertaking that provides a product, part of a product or service to another undertaking, either directly or indirectly, in the context of a business relationship. And that's our definition in 2 of business relationships. Then we've got subcontractors defined and value chain defined. We've got very wide definitions in the directives as to these concepts of business relationships, suppliers, subcontractors, value chains. Then there's a reference to potential or actual adverse impact on human rights. Again, this seems very familiar language from the Ruggie guiding principles. The impacts which will impair or may impair the full enjoyment of human rights by individuals or groups of individuals, including social worker and trade union rights. And that's going to be those rights are going to be set out in an annex. And that's going to be reviewed on a regular basis, and the Commission is going to have a power to amend the list in that annex. Similar thing as to potential or actual adverse impacts on the environment. We see that in number 7. And again, there's going to be an annex, and the Commission can amend that list. It also requires it to be consistent with the Union's objectives on environmental protection and climate change mitigation. And this is something the Union is getting quite hot on. The very first of my talks about the EU was about the environmental impact of its proposed amendment to the MRV and how its climate change ambitions will be partly implemented by bringing in international shipping coming into and out of the Union within the scope of its emissions trading system. Okay, various obligations which now become mandatory. Right, for member states, they've got to lay down rules to ensure undertakings carrying out effective due diligence with respect to these potential or actual adverse impacts on human rights, environment, and good governance. That's Article 4. So this is an obligation on member states. Right, I'm going to pause now. So, Article 5, stakeholder engagement provisions. Article 6 is a publication communication of the due diligence strategy, disclosure of non-financial diversity information, evaluation and review grievance mechanisms. All these really sort of build on what's in the Ruggie guiding principles, but it's going to be mandatory if this gets approved and becomes a directive. It's mandatory in the EU. Now, as regards member states, they're going to be involved in supervising all this due diligence stuff. They're required to designate at least one national competent authority to supervise the application of the directive and to disseminate due diligence best practices. Taken in Article 13 gives them the power to open investigations on undertakings. And then we come to some of the hard bits. Article 18, sanctions. Member states have to provide for proportionate sanctions applicable to infringements of the national provisions under the directive, and to make sure that those sanctions are enforced. And they've got to be effective, proportionate, and dissuasive, and taking into account the severity of the infringements committed and whether or not those infringements have taken place repeatedly. So there is a big stick which is going to be given to member states to make sure that business enterprises are doing what they are required to do. And in particular, we can have proportionate fines imposed, calculated on the basis of an undertaking's turnover. We might exclude them temporarily or indefinitely from public procurement, state aid, from public support schemes, including schemes relying on export credit guarantees and loans. We even go to resorting to the seizure of commodities and other appropriate administrative sanctions. So it's tough stuff here. Then we come to Article 19, civil liability. First of all, it says that the fact that an undertaking, remember undertaking is defined very widely, respects its due diligence obligations, shall not absolve it of liability which it may occur pursuant to national law. Then, for member states, they've got to ensure that they have a liability regime in place under which, in accordance with national law, undertakings can be held liable and provide remediation for any harm arising out of potential or adverse impacts on these three things: human rights, environment, or good governance, that they or undertakings under their control have caused or contributed to by acts or omissions. So I think this is something which would actually make it much easier to bring civil proceedings against companies like Shell suing them in the Netherlands in respect of alleged environmental torts being committed by their subsidiaries operating in other countries, such as Nigeria. Whether this actually comes to pass is another matter, but if it does, it's quite a significant piece of EU legislation, which is going to, there will be, obviously, it's a directive, so there's going to be transposition going ahead through the member states, but maybe by, say, about 2025, we will have these provisions in force in member states, and particularly the civil liability requirements. There will be measures taken by member states to ensure that you can have a liability regime. So that's the end of my third talk, and thank you for your attention.